So I want to welcome everybody. I'm Mike Coffey. I'm president of Imperative Information Group. We're a background investigations firm based in Fort Worth. I'm an HR guy. I've been in and around HR for 20 plus years, and I have the unique privilege of working with a lot of really smart HR people, a lot of clients who I get to consult with on all kinds of, especially employee selection and employee relations type issues. But my bills mostly get paid by Imperative Information Group, the background screening company that I started 15 years ago. I speak to SHRM chapters all the time. That's probably one of, you could say, a passion of mine, but also our primary, that and this marketing stuff, these webinars are our primary marketing efforts. We don't have salespeople out beating the bushes or anything like that. We found that when people are ready to make a change in their background screening process, hopefully they know and trust us by that time, and we can help them. We do offer these webinars for HRCI certification, and one assumes next year at some point for SHRM CP and SCP credit as well. We'll see how that plays out. If you want to get all my takes on the SHRM certification process, you might want to find me on LinkedIn and look at my most recent Pulse post on LinkedIn. But all that said, I'm not a lawyer, and I'm especially not your lawyer. So that's important to say, just because I don't want you to take anything I say today as strictly the way you need to do this in your organization, because especially if you're a multi-state employer, you may have considerations from state to state that vary, and even in some cases maybe municipality to municipality. And so what works for you in your organization may not be the best fit for the next person on the line. And likewise, my overview is intended to be the things that I talk to clients about, the kinds of solutions we present to them, and work with them to help implement. So you do want to talk to your lawyer before you change anything that you're doing. I think the way we approach this is the right way for HR people to approach this stuff, but sometimes legislators don't agree with us. And so, especially if you have knucklehead managers, and we all do. I mean, at some place in your organization, there's a manager who, no matter what you tell him, he thinks he knows better than HR about how to do recruitment and selection, and he's the same guy who's asking these tricky questions about, how many angels can dance on the head of a pin, and he's making employment evaluations based on that kind of stuff. So, but if you've got a number of those, you may want to be a lot more conservative in how you approach things, and maybe a lot of this stuff needs to happen strictly inside of HR. So there will be a certain amount of the gospel according to Coffey in what we talk about today. And that's basically my take on some of these issues based on my experience with hundreds of employers over the last 15 years and just, common sense, which isn't always so common from an HR point of view. So let's get started. Whenever we talk about using criminal history to evaluate an applicant or an employee for continued employment even, I always want to start with reminding ourselves why we even care. Why do we care about criminal history? Why do we run background checks? And first of all, we want to protect our own employees, and we want to protect the public from the bad acts of someone, either intentionally or unintentionally, that could bring harm. And employers also have a responsibility to protect, for their owners and shareholders, to protect their own assets, and then you've got a reputation to maintain as well, and that's perhaps one of the most difficult things to repair once it's gone wrong. And if your reputation goes south because of something an employee does, it could be 5 years from now, all the litigation could be over, and maybe your company won all of the litigation. But people will always drive by your office and say, you remember, that's the company where XYZ happened. And you'll always be that company. And it's, we say Tylenol scare, and we all remember something that happened in the 80s. And so it's that kind of thing. And so putting the right person in the right job is really important. So that's why we run background checks. That's why employers care about this stuff, so you can evaluate your candidates appropriately. So let's do a real quick survey here. Let me launch this. So do you have a policy covering the use of criminal history information in your organization? Not a background screening policy per se, but a policy that says, that talks about this kind of criminal history is of concern, this kind of criminal history isn't necessarily of concern, this is how we evaluate criminal history in our organization. Let's see, we're about a third of you have voted. Let's get a few more people in here. Okay, we're almost there. Let's see a few more people jump in there. And I'm going to close it when about 2/3 of you voted. Let me see if I can get the computer gods to agree with. There we go. Let me share these results with you. Turns out 41% of you said yes, you have some sort of policy. 22% of you said no, we don't have a policy. And 37% of you said sort of, and that's what I see a lot of. A lot of organizations have some sort of policy that says, yeah, we use criminal history and we don't discriminate and we make sure that we don't create a disparate impact in our hiring decisions, but it doesn't often give employers a real good standard for ensuring that they're consistent over a period of time. And a lot of people of that, I would guess that a lot of the folks with the 41% who do have a policy, either you've got a lot of variations to your policy because it's probably written pretty narrow, and then you know, when you're being practical, you have to make exceptions and make decisions outside of what your policy says. And I talk to employers a lot in that situation. They wrote a policy that sounded really fair, but when the rubber met the road and they had this candidate that either they really needed to hire because he had a unique skill set, and they had to find a way to, you know, put additional controls in place to make sure that he was, you know, could be successful in the role and not pose a risk, or the other way around. They saw a candidate whose criminal history they hadn't expected, and it really causes them concern about putting that individual in a particular role. And so they had to vary from what their policy may say. So I think there's a lot of variations that go out there for employers. So let's talk about some of the things employers might do and how they might use criminal history. The first way employers certainly use criminal history is to exclude certain applicants from certain kinds of jobs. For instance, you would not want this this guy on the left here who's got a, you know, let's say he's got a recent and, you know, DWI in the middle of the afternoon outside of Applebee's. You wouldn't necessarily hire this guy to drive the forklift in your organization. And so there's certain kinds of offense in a certain period of time certainly would exclude somebody from certain kinds of jobs. And I'm sure in your organization you can think of certain kinds of offense that would prevent you from hiring certain people for certain kinds of roles. But the way employers also use employment or criminal history in making employment decisions is to evaluate candidates and compare candidates A and B. So if you've got a candidate who let's say you've got an open position, you've got two similarly situated candidates, their experience, their education, their work history, those things are all pretty much standard between them. They're pretty common. But you get one guy who maybe he's got a criminal history that's not directly related to the job as far as the nature of the offense to the job, but maybe his criminal history is just a bunch of petty stuff over a period of time, a disorderly conduct here, maybe a public intoxication, maybe a theft by check, and just over the last several years, he's just been consistently kind of in some sort of trouble. And then you've got the same candidate, but with no criminal history, same qualifications. Who's going to be your easier person to manage? Who's going to be most likely to be most successful in your organization? And I think, just like you would evaluate the reasons for termination for an employee from leaving a previous employer, or other things that come up in the course of understanding who the whole applicant is, I think certainly you want to evaluate somebody's interactions with the criminal justice system as you evaluate candidate A and candidate B. And this is the way a lot of employers really ultimately use criminal history, but they don't have policies that necessarily allow for them to that way. And so they're just looking at kind of their gut instinct. And some of the things we'll talk about today will hopefully give you some tools to better evaluate some of that. Let's get into the legal side of this real quick. The main concern on the use of criminal history is the possibility that you're going to end up violating Title VII of the Civil Rights Act. And of course, Title VII created those protected classes: race, color, sex, national origin, and religion. And that was passed in 1964, and the last time it was modified with regard to what we're talking about today was 1991. President Bush signed into law an amendment that basically codified what was already decided in the Green versus Missouri Pacific case, or really the later case, or the earlier case, Griggs v. Duke Power, the idea of disparate impact. So let's talk about different ways, the two kinds of disparate action that you have. First of all, under Title VII, you've got disparate treatment, and we always recognize that. When we see it primarily, it's we're not going to hire women for this job, or we're not going to hire people of this religion for this kind of work, or this, we're a Christian organization and we're not going to hire anybody who's a Muslim to work in this organization. Those kinds of things, we understand those, and certainly the most obvious in our history is we're not going to hire African Americans to work in this company or to work alongside white employees, or certainly to supervise them. Those kind of disparate treatment, we recognize that, and it's become significantly less common in the U.S. than it used to be. Not to say there's not a few knuckleheads out there still doing stupid stuff, but their competitive advantage is quickly eroding because of that, I think. But then you've also got disparate impact, and this is where you have policies that on their face seem neutral, and they don't seem like they're going to affect anybody because of their race, their national origin, or any of those things. But when you implement them, they have a greater impact on people in a protected class. And you can't, and there's not a business necessity for this policy. That makes it illegal disparate impact, illegal discrimination under Title VII. And the first case to really deal with this is 1971, the Griggs v. Duke Power case. And Duke Power had requirements for education and intelligence for people who become managers. And after they implemented those policies, an African American employee sued them, saying this is because this was the South, and we're talking 1971. So this is people who grew up in an age in the South, especially where there was significant discrimination in education opportunities, and having a high school diploma was a privilege denied to many African Americans. And so Mr. Griggs sued Duke Power, and the court recognized that, in fact, this policy didn't have a business necessity for it. And you say, whoa, wait a minute, surely we want our employees to have high school diplomas. Well, in the Duke Power case, the plaintiffs were able to prove that, well, before they had this policy in place, Duke Power had employees who did not have a high school diploma and were managers. They were white employees, and they didn't have the high school diploma, but they were good managers, and their performance was no different than those managers who did have a high school diploma. So the Supreme Court said, look, the statistics demonstrate that African Americans in the population that you're recruiting out of didn't have the same educational opportunities as these white managers, and the white managers you've got on staff or you had on staff who didn't have their high school diploma, didn't, performed at the same level as everybody else. It wasn't a predictor of success in the role of manager. So you're creating a stumbling block for African American employees to become managers. So that was the idea behind disparate impact. And then a few years later, in 1975, there was the Green versus Missouri Pacific case. In that case, Mr. Green was an applicant who had been a draft protester during World War II, during the Vietnam War, sorry. And he ended up serving, I think, about 18 months in federal prison because of his anti-war activities. And so after he got out of prison, within a couple years, he applied to work at Missouri Pacific Railroad. Now, Missouri Pacific, MOPAC, had a policy in place that said, we will not hire anybody with a criminal history, period. Didn't matter what it was, how long ago it was, or anything. They just said, yeah, we don't hire criminals, period. And Mr. Green sued, and the case was in the 8th Circuit, and the court in that case said, well, wait a minute. The statistics demonstrate that African Americans in the U.S. are arrested, prosecuted, and convicted at a higher rate than the white population. And so the court said, just having a blanket exclusion, a bright line rule like this, is going to adversely impact the people in protected class based on race or color of skin. And you've got to have a deeper business necessity for that. And if you're going to get into a deeper business necessity related to your evaluation of criminal history, then you need to look beyond just the fact of, yes, they've got some criminal history in some place in their past. You need to look at the nature of the offense, the time that has elapsed, and the nature of the job, how those things all relate to each other, and how much risk can you afford in this role for somebody with this kind of history. Now, it's important to note that the court did not say employers must look at these three things and only these three things. These items were in different paragraphs. They were just the kinds of things that the court talked about. And we often hear these, they're called the green factors commonly. And we hear these cited like they were gospel, but that's not the court's point. The court's point was the employers need to have a business necessity for the discrimination. And if you've got a solid business necessity for your case, and there's no viable alternatives to that, then you can make your hiring decision, even if it adversely impacts somebody in a protected class. And as of right now, under federal law and in most states, being a former criminal offender is not a protected class. So what's the whole point? The whole point is you avoid disparate impact claims by reviewing the total applicant. And that means that, let's look at everything they bring to the position. Let's look at whether this is the best candidate based on skills and everything else. But I've got a concern about their behavior because they've consistently been in these these little seemingly minor scrapes with the law, or they've got a significant criminal history that says, well, I can't put somebody in this position handling cash who's had a robbery conviction in the last 5 years. It just doesn't make sense. Or we're not going to hire somebody as a CFO with an embezzlement conviction, maybe ever. So those are the kinds of things that you need to look at. You review the whole applicant, but there may be cases where you may hire somebody with a criminal history that even gives you a little concern, but their skill set and their work history and everything that they've done since their offense tends to demonstrate that that's not necessary. That criminal history in and of itself isn't reflective of who the person is and what they bring to the table. So review the whole applicant, and you're going to hear me say that over and over again. What you don't want to do is something like this. You don't want to have a criminal bright line rule that says clean background check required. And these are examples that you might see on Craigslist or someplace, usually small employers or employers where a hiring manager ran out there and posted a job on Craigslist or on some bulletin board someplace, without working through HR. But clean background check required. Well, what are you doing? You're telegraphing to the applicant who's got a theft by check from 10 years ago, or something really unrelated to the job and minor with some distance in the past, that, well, we're sorry, we're still going to exclude you because of this really minor offense. No felonies allowed, and that's the one that kind of surprises people. Well, you mean we even have to hire felons? Well, I'm not saying you have to hire felons, but I think you want to evaluate the felony and see what happened. In Texas, your third DWI, driving while intoxicated, is a felony. So if you're going to hire somebody to sit at a desk all day long and operate a computer, and they never drive in the course of their work, they don't operate any dangerous equipment or heavy machinery, is the fact that they got their third DWI 10 years ago really relevant to this job? Assuming they don't have any other criminal history, I would suggest it's probably not. And so, again, you want to look at the conduct. What did they do? And no convictions for theft or dishonesty. And that's another one that surprises employers. But theft or dishonesty, okay, you're looking at a 40-year-old candidate, let's say, or just to take the age issue out, let's say it's a 39-year-old candidate who 20 years ago at the age of 19 was convicted for shoplifting. Their work history since then is good. Let's say they went ahead and got their college degree. They've moved on. That one action 20 years ago isn't really reflective of who they are, even though it is a theft technically for or a conviction for theft or dishonesty. So I hope that's kind of gives you an understanding of, you need to be more nuanced in your evaluation of these. The other thing I want to say, and we'll talk about that a little bit more, but is you want to pay attention to the conduct that the person is engaged in, not the offense, not whether it's a misdemeanor or felony, or even how the court moved the case through their backlog. There are a lot of ways the courts do things to expedite the case and all that. What you really have to ask yourself is, what did the person do, and how does that conduct, even if they weren't convicted, maybe, if you were to ask the applicant during who's a truck driver, you were to ask him, when was the last time you drove drunk? And he said, I drove drunk last night. You wouldn't hire the guy, even if he hadn't been convicted, because of the conduct that he's admitting to. Well, a criminal conviction or even a deferred adjudication where somebody's pled guilty or no contest to an offense, they're telling you, I've engaged in this conduct, and you have to evaluate that against the role that you're reviewing them for. Real quick, let's go through the EEOC's guidance on this issue that came out in April of 2012. It superseded guidance that was released in the late 80s and early 90s from the EEOC, and it was really released after the EEOC lost a couple significant cases that, on employers' use of criminal history. So there's been a lot of activity around this, a lot of discussion around it. The Texas Attorney General and several other states got together and sued the EEOC over their guidance. But the important thing to remember, and they lost, I think there may be an appeal in the works, but the court just said you don't have any standing at this point. The EEOC's guidance hasn't been used against your state, so you don't, until you've suffered some harm, you can't sue the EEOC, and so that's an ongoing thing. But we're going to talk about what's in the guidance today. And again, what you really want to pay attention to is this predictive value of this information. What does this information tell me about what this person's conduct may be in the course of their employment? And that's important, for offenses that, certainly regarding safety or performance, performance issues with what their attention to detail is. I mean, somebody with an offense for some sort of negligent homicide or some sort of operating a motor vehicle with negligence, things like that. Those kinds of things, those are red flags for you if this person's operating heavy equipment, certainly a forklift in your munitions factory, or a motor vehicle in the course of their work. but there's other things, again, like minor offenses, but a pattern of minor offenses that kind of show you this person's going to be a management headache compared to other candidates. And so we would rather have a candidate who's not already demonstrated to us that through their public behavior that they're going to be, you know, somebody who doesn't conform to rules, doesn't respect authority, doesn't work within the expectations set out for them, gets away with what they can, those kinds of things. So let's do another poll. When do you guys inquire about candidates' criminal history? Do you do it on the employment application? Do you do it at the interview or after the interview or after the offer? And you folks who put other, drop down after you click other and put it in the question box. Put your answer in the question box because I'm just curious. I'd like to see that. And while y'all do that, I'll let you know that we are going to answer all the questions at the end. So feel free to ask me questions as well. Okay, and so we'll go through and answer those questions. Let's finish the poll up. And I'm going to close that now, okay? And let me share these results with you and see what we got. Well, about half of you do it on the employment application. About 22% say after the interview, and about a quarter of you after the offer. Then you 8%ers, let me hear from you. Tell me, give me some information after the interview, but right before the offer for final candidate only. So it's after the interview, but right before the final offer. So you've gotten down to your final candidate, and then you ask about criminal history. Okay. Anybody else want to share something? Let's see if I'm missing anything. No. Okay, no, okay, good. Well, we'll go through that. And so we want to talk about some of those things. Let me close this poll. And we'll move on to the next slide. Okay, now what we're getting into now is strictly gospel according to Coffey stuff. This is my opinion, as I've worked with employers, what's proven practical. Let's give employers a tool that they can use that will hopefully help them to avoid litigation, make good hiring decisions, because what you don't want to do, and I really want to stress this to you, beyond all the legal compliance stuff and being worried about getting sued, the other thing you don't want to do, though, is have these arbitrary rules that eliminate otherwise fully qualified candidates. If these rules or your guidelines that you're using eliminate people who you would really benefit from having as employees because of something arbitrary and especially something distant in the past, then you've got to ask yourself, why are we doing this to ourselves? Why do we want to make it that much harder to recruit candidates? Why do we want to make it that much harder for the company to have a qualified workforce by having some policy that we haven't really thought through? So a lot of what we're going to talk about today are, in the next half hour, are things that I recommend as I'm talking to clients will help you have a safe and productive workplace and approach it in a thoughtful manner. So the first thing, when we're talking about criminal history, it is the least expensive integrity test you will ever give your applicant. So if it's built into the employment application, which about half of you said it was, then that's if they tell you the truth on the application, and hopefully we've got a whole webinar on developing a good criminal history inquiry that's appropriate for your organization. But if they tell you the truth, then the background check is only a verification that they told you the truth. It's basically your lie detector test. And I really want to encourage you, whenever you ask it, to look at that question that way. Let's ask a really good question that doesn't leave any wiggle room for the applicant, that isn't limited just to felonies or even just to 7 years of criminal history in most states. Let's ask a very fair and open-ended question, and then let's evaluate it fairly. And then a lot of employers put into place something that's called a relevance matrix. And we'll get into the details of this a little bit more, but basically we look at groups of jobs, you know, kind of a class, like administrative clerical positions that don't drive and don't have access to financial accounts, okay? And then we can look at that group of jobs and certain kinds of criminal offense and say, yes, they're eligible for hire, or, well, that gives us pause. We want to understand the details. We'll have a more thorough review of the criminal offense and how it relates to that job, and maybe get more details from the applicant and have our background screening company verify those. So those people are going to be yellow light or a C, some sort of corporate review, that kind of thing. And then there are going to be certain offenses where the person is simply not eligible for hire. So somebody who has a conviction for embezzlement, and let's say it was 5 years ago and they served some jail time for it, that'd be a real concern for somebody who's going to be a bookkeeper in your organization, or somebody who's going to be operating, you know, with access to corporate accounts or even credit cards and things like that. And that, you know, if that kind of offense in a certain period of time, we'd probably eliminate somebody for that from that offense. So what does that look like? It looks like something like this: a relevance matrix where you've got offenses down one side, and then for that group of jobs or specific positions, you've got timelines out there: 0 to 3 years, 3 to 7, 7 plus. Different employers have different, you know, numbers that they work out. And you can say, yes, this person's eligible, yes. Not eligible, red, which would be red, or an N, or they're a C. They're, you know, it's going to be some sort of corporate review. So let's say this relevance matrix was for a car dealership, and this person is going to be a car salesman on the car lot selling cars for the dealership. And he's got, you know, let's say he's got an alcohol consumption or possession offense. And we look at that and we say, okay, well, he's eligible for hire. Somebody with not a DWI, which is a different classification down there, but somebody who has just a simple, you know, open container kind of offense in the public, something like that, or a minor in possession, an underage student, you know, maybe in college who got caught with a beer, something like that. Yes, they're eligible for hire across the board. Well, that's not gonna, that will not in and of itself, by itself, exclude the person from consideration. And then maybe they have a computer crime of some sort, and we don't know what that means. And there's not a good way to classify all these different kinds of computer crimes into multiple categories that are easy to use. So what we just say is we want to understand what happened. So we'd ask the applicant, you know, what was the offense? Illegally accessing a computer network. Well, was this something they did in high school as a prank, and it's been several years since then, and you know, they've since got their college degree, and now they want to be a car salesman for you? Maybe that's not of concern. But if they committed some sort of actual financial fraud using a computer account, or maybe if they used computers to access child pornography, maybe those are bigger concerns for somebody dealing with the public, and we want to be more cautious. So we'd get the details and evaluate them, evaluate the applicant, his history, what he's done since the offense, and the rest of the applicant pool against them, and then we make a decision. That'd be a corporate review of some sort. But then auto theft, you might say, you know what, if you've been convicted of stealing a car in the last 7 years, you cannot work on our car dealership. And that would probably be a very job-related exclusion that would make sense to most of you. And then if it's more than 7 years, they're a C, they're corporate review. Well, if you've more than 7 years ago that you were convicted of that, we'll look at the details and figure out what happened and kind of see what happens. You know, it's like assault. You may not, you know, if you're the HR person, you may not have a real concern about hiring somebody with an assault conviction if it was, you know, say 5 years ago, unless it was the HR person that their previous employer they assaulted. Then suddenly it's maybe it's a little bit more relevant, and you want to understand, you know, is this somebody who in a management context, in a workplace context, is going to, you know, threaten violence if things don't go the way they want them to. Look at more detail there in the context of the offense. One thing you'll often hear when you're talking to employers is, my lawyer said, and you know, that wasn't going to be on my record. And usually what they really mean is the lawyer didn't know what they're talking about, because most of the stuff is on your record. Your record is open to the public. Even dismissed cases are available. What you want to know as an employer is not were they convicted or was the case dismissed because they served probation and deferred adjudication and the case is dismissed at the end of it. What you really want to know as an employer, is it reasonable for me to believe the person engaged in this conduct? And what does that conduct tell you about them? That's what's important. It's not the, again, it's not the way the court processes the case. That's not nearly as relevant as, did they engage in this conduct? And there's times where even a dismissed case will be of interest. Now, if you're a multi-state employer, there are states where you cannot evaluate dismissed cases, regardless of the reason, even if they, you know, the person admitted in open court they did this thing and the case was dismissed because of, you know, maybe they served probation and got deferred adjudication and it was dismissed after the probation. There are states where you cannot consider that at all, California being an example. So you do, again, if you're a multi-state employer, need to pay attention to that. But you'll hear from applicants often that that's not even supposed to be on my record. And well, what they're really telling you is their lawyers don't understand how criminal records are collected, maintained, stored, or shared with, and how employers use them. But even the EEOC has recognized that employers can use arrest records. You hear this all the time, you can't legally use arrest records. Well, that's not true. Even the EEOC has said employers can use arrest records. It just has to be reasonable to believe the person engaged in that conduct. Now, from a practical point of view, I don't advise clients to look at just arrest records because they're kind of a mess to get hold of and to understand all the context of what happened. But what we do say is we're going to report to our clients everything we can legally report to them, which is, you know, in most states means we can report dismissed cases to them. And I encourage employers to look at those dismissed cases and say, you know what, I want to understand that offense in and of itself would be a concern to me. So I want to understand the context, what happened, why was the case dismissed? Maybe they were truly found not guilty. Then that tells you one thing, there's not, you know, a jury couldn't find them guilty beyond a reasonable doubt. But maybe they just served probation or pled guilty in another case or something else. You may want more detail before you make the hiring decision on those. Like I said earlier, misdemeanors versus felonies. Look at the conduct. Don't look at the way that what's a felony in Texas could be a misdemeanor in Oklahoma. And so just because that's the way that state has written their laws in their penal code doesn't mean it's relevant for your consideration. What you should be really focused on as an employer is, what did the person do? Is it reasonable for me to believe they engaged in this conduct? And if so, how is that related to the job? And then how does that factor into my evaluation of this candidate against other candidates? So here's a question I get a lot, and employers often have different answers on. So let's launch this. How do you guys treat pending cases? If your applicant tells you, or you find out during the interview process at some point, you know, background check or whenever, that your applicant has an open criminal case against them, how do you treat those? Let's see what we got here. I should probably put that depends on the hiring manager on all of these, because I know that's often a consideration. And sometimes that's a fair consideration. Your hiring managers know the environment that people are going to be working in. They know the risks. And I would encourage you that your hiring managers are folks who are really familiar with what's going on the front lines in your organization. Have some input into how you evaluate this stuff. Okay, let's go ahead and close this. And let me share those results. Almost half of you said it depends on the hiring manager or the job as to how you treat pending cases. 10% said if they got a pending case, we're not even, you know, we don't care. We're not even going to look at the pending case. 28% of you said we ask them to reapply after the case has been finalized. Let me share those. Yeah, I think, well, it looks like maybe y'all are having a computer glitch on that one. Let me see if I can hide it and then share it again. Maybe you can see the results better that way. There you go. Hopefully that looks better for you. And 17% said other. So, but you know, the ways to look at this are varied, and a lot of different employers have different responses. What I most often encourage employers to look at first is, let's treat the pending case as though the person actually engaged in the conduct. Let's look at that first. Okay, so would that conduct in and of itself prevent you from hiring this person, or would it give you pause? Because if it's not a concern, and especially if it's not something that they can go to jail for, or so that wouldn't be available for work, which is, you know, a lot of offenses, then you may not be concerned about the offense at all. But if the conduct is something that gives you concern because of the kind of work they're going to do, then you have other considerations. Or if the pending case, if there's several of them out there, you know, the guy has, you know, maybe multiple court dates coming up, or there's a lot of history, or he's got other criminal history as well that ties in with all of it, then you may want to have a deeper review of it. Most often, I encourage clients, if they're concerned about what the person's been charged with, is go ahead and let us pull criminal records, pull copies of the court records for you, and so you can actually see what the person was charged with. I always encourage you to go ahead and get the applicant to write down what's going on, to write down what they're charged with, their side of the story. Help, you know, they need to help you understand what's going on, and then go get court copies through your background screening partner, and let's see if that makes sense, if what they told you was the truth. Because if the applicant's really straight with you and honest about it, and it verifies with the court records, you may be more likely to hire this guy. What happens, unfortunately, is often the applicants lie to the employers. They say, yeah, I've got, you know, they know they're going to have out some time off for court dates here in the next few weeks, and so they tell them one story about what's involved, the case is involved with. You know, yeah, I got stopped with, you know, less than an ounce of marijuana, and you know, it's, you know, it wasn't even mine. It was my girlfriend's, and it was in the front seat of the car, and the cop arrested me. And, you know, I think we're going to get this all cleared up. Then you go pull the court records, and now he was caught with a pound of marijuana. And, you know, he had a whole block, and he was getting ready for a massive party or to sell it or something. And, you know, and when they tell you that, and one thing, and the court records show another thing, then you know, I think you've got your answer as to whether this is an applicant that you really want to spend your time pursuing. And then they can always, after the case has been resolved, reapply. That doesn't mean just because they were found, the case was dismissed, you're automatically going to hire them, but it does tell you that, well, you know, we're willing to reevaluate this if in the future, when this is taken care of, we have a position that'd be appropriate for you, and we'll reevaluate this and look at all the information we have available then. Another thing that comes up quite a bit, or what about warrants? What is our policy going to say about if somebody's got a warrant for their arrest? And some employers have policies that say, well, it depends on what the warrant is. If it's a felony warrant versus a misdemeanor or traffic or something like that, my suggestion is always make them take care of it. You know, we want employees who've taken care of their business, who don't have anything hanging out over them. And we sure don't want an employee who's going to go out to lunch, get stopped for running a stop sign or a red light, and then end up in jail and not be available in the afternoon. So, you know, we're ready to extend you an offer, but we need this stuff taken care of within the next 5 business days, or we're going to have to rescind the offer. And let them take care of their business. If they're willing to take care of the warrants, whatever they are for, then that's great. You can move on. But if you know, if they can't clear up the warrants, or when they go report, and this happened to one client, they had warrants, and the sheriff's department, you know, they called the sheriff's department. The sheriff's department said, "Come on, you know, come on down. We'll take care of it." And the applicant went down there, and the sheriff put them in jail. And the sheriff wouldn't let them out until until the person had appeared before the court, and the person, you know, ended up with a significant criminal case against them. And so, those are the kind of things you want to know before you hire the person. So I think you want them to take care of their business before they get into the criminal history. I mean, before they get into your workplace, make sure you understand what's going on with them. And what about cases that are conspiracy to commit this offense? Conspiracy to commit murder or to distribute drugs or whatever. Conspiracy or attempted. My advice to you as an employer is, they were trying to conduct, they're engaged in this conduct. So just because they weren't a very good criminal, doesn't mean that you should give them extra points in evaluation. This is what they were trying to do. So conspiracies or attempts, same issue, and treat it just like the conduct that they were attempting to engage in. And then we've mentioned this several times, but I just want to keep reinforcing it because I think it's something that gets lost in a lot of employers' considerations. You remember Otis on Andy Griffith? He was the town drunk, and he'd get, Barney would roll him into the jail and just let him sleep it off, that kinds of thing. He was a constant, though, visitor to the jail. And you're going to have candidates along the way who their criminal history doesn't cause you a lot of concern, but they get in trouble a lot. You just see this constant petty stuff that, these aren't, criminal kingpins or anything like that, but there's people who don't have very good life management skills. And if they don't, what does that tell you about how they're going to perform on the job? And some of you are probably shaking your head and saying, yeah, they'll fit right in with the rest of our employee. But, do you really want to add another knucklehead to the group? Or I don't know, what do you call a group of knuckleheads? Is that a bunch of knuckleheads or a gaggle? I don't know. But anyway, so keep evaluating that. Remember that just because the offense doesn't eliminate somebody from consideration doesn't mean that it isn't something worth considering when you're evaluating the applicant. And do remember that some states and even municipalities have ban-the-box laws and other limitations on what employers can consider. So ban-the-box is a national movement to remove the criminal history inquiry from the employment application altogether. And a lot of multi-state employers like Target and people like that have removed the criminal history from their employment application completely. A lot of municipalities have done that strictly for their local government employers in several states. I think there's 13 states now that have banned the box for public employers, and I don't have the list in front of me. I think it's 6 or 7 states have banned the box for private employers as well. So if you're a multi-state employer, you need to look at where you're operating, and it may be easier for you to wait and ask the criminal history question after you've already interviewed the person, just so you've got a consistent practice across the board. But good old Texas, where many of you are from, looking at your logins here, and where we're based, doesn't have any requirements that way. So how do we get to this thing? How do we develop a tool that helps us fairly evaluate, at least individually, criminal actions? Well, we've got 3 tools that we've developed working with clients over the years. And I just want to quickly run through each of those. They're not really hard to use. They just take a lot of time to put the time together. And I think you want to have, as you're reviewing this stuff, you want to have HR in there. You want your hiring managers in there, or somebody who's really involved in understands the risks associated with those jobs. You might want to have your background screening partner involved in it, and certainly at some point your legal counsel needs to review it as well. The first tool we have here is this position risk review and checklist, and what it looks at is what kind of access does a person in this role have? What level of supervision do they have? What kind of work environment are they working in? And what are their job responsibilities that are related to different kind of risks? So you've got this, and you say, okay, so we're looking at administrative clerical positions that don't handle cash, and so how much access does this person have to these kinds of information? How supervised are they? That makes a big difference. Somebody who works off-site, operates a motor vehicle, like an outside salesperson or a service mechanic or maintenance staff who travels to client facilities with very little supervision, that may make a difference in how much you're willing to put up with. Somebody with a criminal history, maybe a certain criminal history may be appropriate for an in-house position that's pretty well supervised, but you're less likely to send them out where they're not going to have a lot of constant supervision, those kinds of things. And certainly the kinds of things that they do in the job would be relevant. So this kind of helps you identify the risks associated with the jobs, and then you take those over to this matrix that we've put together. And this first matrix just says, again, it goes through all those kinds of things for the access that the role has, the supervision and work environment the person's going to be working in, and the job responsibilities. And it says, let's look down these and say, if in our organization, if somebody's committed a crime against a person, murder, rape, assault, those kinds of things, where they've physically caused injury to another person, and this person has access to personally identifiable information, is there a correlation there? And I would, depending on how your organization, you might or might not be particularly concerned about it. But if there is some correlation, you probably want to go ahead and mark those where they intersect. And so this kind of gives you just a big picture view of how these risks relate to different kinds of general broad categories of offense. Then you can take it over to the actual matrix, and you see we've got these categories that we had on the previous, like crimes against persons, financial crimes, things like that. Then we've broken it down into specific offenses, and you can say for this group of jobs, 0 to 3 years, 3 to 7 years, depending on how old they are. Now, that's one question that comes up a lot, is how far is far back enough? And there have been a few studies on this, and generally 7 to 10 years, if a person hasn't committed any criminal offenses in that time period, and they've been out from under some sort of custody or supervision, people perform a lot better in jail than they do. They don't commit new offenses typically in jail, but they also perform better while they're reporting to a probation officer or parole officer than maybe they do when they don't have that kind of constant supervision. So, how long have they been operating without some sort of supervision or outside of custody is the first question. But then generally the studies say 7 to 10 years after an offense and their release from custody, a person is no more likely than the general public to commit another offense. But there are some significant problems with some of those studies, and certainly that does not mean that somebody who's got a sexual assault conviction should ever work directly with children. I mean, I think that's a risk that most employers recognize, and we're not going to do that. And there may be other items that you want to review in the in the context of employment, where you say, you know what, that kind of offense, I don't care how long ago it was, it's just not appropriate. And it may be, it simply wouldn't do, this person has to go visit clients and has client interface a lot, and we wouldn't ever want a client to know that, to understand that we sent somebody with this kind of offense into their organization. It just, we've got a fiduciary responsibility to this client, and somebody, even if it was 20 years ago, who had some sort of significant financial fraud in their background, we just can't send them out there. We can't, they're just not appropriate for that job. So this helps you quickly, though. Once you fill this grid out, you can look at an employment application, and somebody's just got one offense. You look at it and you say, okay, based on our own policy, this job, this offense is not it's not a deal breaker. We can still hire this person. You can proceed with the applicant. But you may have others who say, well, our policy tells us right up front that somebody with this criminal offense in this time period is not eligible or hire for this kind of job. And those would be the exception. I mean, that should be a relatively small number of offenses when you look at all the different kinds of offenses that are there. But it may be, it'll happen enough that it'll make your process a lot easier. And it's fair to the candidate, because it keeps the candidate from going through the interview process and through all wasting his time when at the end of the day, you know, you can't hire them. And I've got a whole webinar on that ban the box issue, and I've got some real concerns about ban the box. I just think it's really inefficient for employers. And I did do a recent blog post on our website about the ideas behind ban the box and kind of why they're fallacies. So I encourage you to go look at that. But we do have a whole webinar on it, and it's recorded on our website, so you're welcome to go look at the recording of that webinar as well. One last thing, I'm going to say it again, look beyond exclusions. We're not using criminal history strictly to eliminate people from consideration. We want to look at the whole applicant and compare candidate A and candidate B. So now I will go to questions, and oh, look at that, I didn't update my last slide with upcoming webinars, but we do have a webinar in January. Okay, let me look at some questions here and see if we can get those answered for you. Okay, lots of questions, so let's see. What about the 7-year limitation on background checks that employers usually apply? We wouldn't know about 20 years ago. Well, I would suggest, first of all, unless you're in one of the handful of states, and it's only a few states that limit an employer from looking at criminal history for 7 years, I would suggest that you don't want to do that. You want to know everything, because there are a lot of significant offenses that are 20 years ago, and they may have spent the last 15 in prison for them. So if you're only asking about criminal convictions in the last 7 years, then you're going to miss a lot of information. And as far as the background check goes, there is, under federal law, a background screening company can report convictions to you as the employer forever. There is no limitation under federal law. Now, a handful of states limit what we can report to employers, California being one. And in California, I cannot tell an employer about a murder conviction that's 8 years old. As dumb as that sounds, I can't do it. California's got a whole bunch of other crazy rules too, but that's why California is losing all their businesses to Texas. But there's no federal law. The reason many employers still have that 7-year idea is because, quite honestly, the background screening industry, a lot of companies know that they're not. It's easier and it costs them less to only report convictions in the last 7 years, and so. If you don't have to spend as much time reporting records that are 8, 10, or 20 years old, and like I said, there are times where those are relevant, but just because it's on the background check doesn't mean it's relevant. Only the employer can determine that. So you may see stuff you don't care about on the background check. That's perfectly fine. That just means your background screening company is doing their job, and you have to evaluate whether it's relevant. A company like Imperative, or really just about any good background screening company, will report to the employer everything that they can legally use in making the hiring decision. So we're constantly looking at where is this employer hiring for this position for our larger multi-state employers. Where is this position going to be? Where does the applicant live? What are the state laws in each of those? And can the employer use this information? And we're not going to give the employer anything that would give them opportunity to shoot themselves in the foot. But really, if we see something that's more than 7 years and it's legally reportable, we're certainly going to tell the clients about it. What if you have candidates who are recent college graduates and they have some criminal convictions, assault, DWI, being a knucklehead basically. They are just starting their careers and haven't had time to prove they have changed. How much should that weigh in on the hiring decision? Well, thanks for that, Becky. And I talk to clients a lot about these issues because a lot of kids do dumb things. Well, and quite honestly, a lot of adults do dumb things. So you might hire somebody with a marijuana, somebody who got caught with a marijuana conviction in the last year and a half, 2 years, something like that. And I would treat, really regardless of whether they were a student or they were a full-grown adult I would treat it pretty much the same. I would say, okay, well, this offense in and of itself doesn't eliminate them from consideration, if that's what your policy is. But we're going to review it, and perhaps we're going to hire them, but we're going to put in a few extra controls on this person. We're going to tell them, as a condition of employment, you're subject to random drug screening at a higher level than everybody else in the organization. Maybe it won't be random. Maybe we're going to schedule. We're not going to tell you when it is, but we're going to schedule drug screening for you at least once a quarter, and you won't know when it's coming. Things like that. We've helped clients do things like that in the past. If you know, there are such things as youthful indiscretions, and certainly we want to accommodate those. You know, we don't want to miss out on hiring a really good candidate at any age because of one dumb mistake. Now, an assault would be, you know, for me in different contexts would be a larger concern than you know, maybe a minor marijuana conviction. But again, I would apply it just like you would across the board. Look at the whole applicant. Look what they bring to the table. Give them that opportunity to you know, to demonstrate through their college activities what organizations they were a part of, all of that, and evaluate the whole candidate if it's not something that would be an outright obstacle to them being hired. Let's see. What about the ban the box on the application issue? I talked about that a little bit, and there's a lot more information on our website, including the ban the box webinar that may be helpful. So I'd suggest you go look at that. Somebody said we inquire with the applicant about the situation and consult with our legal department to make a decision based on the conversation with the applicant and the business need and the job requirement. I think that's probably, if you're not hiring a ton of people, or you've got a unique applicant pool where you're not getting a lot of criminal history, you know, then that's probably something that you can easily do. I've got clients who, you know, like my oil and gas clients, they've probably got criminal history on 35 or 40% of their applicants. And they're not eliminating that many of their applicants, certainly, but that many of them have history. And so they're struggling to find the folks who are qualified and will work in the oil field for whatever they want to pay them, because that's such a competitive market. And so they're you know, much more forgiving of a lot of offenses than they might be for in other contexts or in a white collar context. How do you recommend handling multiple convictions on one candidate when they occurred 20 or more years ago? Assault, possession, DUI, evading arrest. Should this be considered if they've been clean since? If it was more than 20 years ago, I would say it's probably not relevant for those kinds of offense. I mean, people do change. They learn their lessons. The older you are, the less likely you are to engage in this conduct. There are studies that suggest that as well. And if somebody's kept their nose clean for 20 years, I think, you know, I would still want to know about the information, and I would want to give the applicant a chance to tell their side of it, but it wouldn't, in most cases, factor into the employment decision for those kinds of offense. Now, if they were in, you know, one thing that tells you a lot about an applicant is if they got some sort of parole or probation, and you get your background screening company to dig in for you and find out how they did on their parole and probation. Do they have a lot of, you know, violations of that? Did they have a hard time keeping clean? Did they have dirty drug tests? Did they have warrants issued because they failed to appear at with their probation officer, those kinds of things? If you see a history, a pattern of that gives you a lot more indication, and that may be more relevant to you in making the hiring decision than even the offense, because again, this is somebody who may be harder to manage. But on its face, something 20 years old, most offenses would not be a big concern for me. Let's see. Where's the best place to find the state regulations on background checks? I'll tell you, Susan, it's you should be able to get that from your background screening partner. We share that with our clients who are multi-state, and that's probably the best places with your background screening partner if you've got specific questions. But if you've got specific questions you want to ask, shoot me an email. I'd be glad to help if I can. Your own legal counsel can probably put something together for you as well. That's going to cost you, and it's a lot of research. Also, the National Employment Law Project probably has some of that information on their website. That's NELP.org. They're a pro-worker, and I think it's safe to say in most cases anti-business, anti-employer organization, but they're definitely pro-employee. But they track a lot of this, and they're one of the big advocates for ban the box and that kind of stuff. There's also the Privacy Rights Clearinghouse, which may also have some information that would be helpful. But really, go to your background screening partner. They should be able to give you the information that you need. How do you know if candidates have outstanding warrants? That should show up on the report. It'll typically, in most jurisdictions, we see warrants when we're doing searches for the county criminal records, because what happens is the case is filed against the person, then they didn't appear, or they or the police are actively looking at them. But if they've been indicted or there's a misdemeanor information filed against them, then usually we'll see that with a warrant. Also, we'll see it sometimes on traffic warrants because their driver's license will be suspended. And that's why I always encourage employers to run a driving record on every applicant, even if the person doesn't drive, because their driving history may tell you about their safety awareness and how their safety performance is. But it also gives you, it's a great source for an independent government verification that this name and date of birth and address that you've been given all match. It still doesn't mean it's necessarily your person, but at least they all match. And if their license is suspended for unpaid tickets, that's a flag to your background screening company that they should look for those warrants. There ought to be warrants out there for unpaid tickets, things like that. Can I have a copy of the PPT? Yes, the PowerPoint. Yeah, what we'll do is everybody will get a survey in the next hour, hour and a half, hopefully. And when you do, you take the survey, and at the end of the survey, there will be a link to download the slides and notes, and there will also be the HRCI information. If you're a certified professional and you need your certification information, it'll be at the end of the survey too. So it's the only thing this webinar costs you is an hour and taking the survey. One last question, let's see. What if there's something derogatory that is being said about a potential candidate that does not prevent an employer from hiring them, but it does get spread through the hiring manager knowing someone at a previous employer? How can a candidate find out what is being said in order to stop what is being said? Okay, not sure I know the answer to that one. You know, I would definitely train all of my managers, you know, and all my clients, and I would suggest you train all your managers that, you know, everything that comes up, whether it's an employment verification or it's a information comes back on the background check, all of that should be held strictly confidential. There's no reason for somebody who doesn't have a direct need to know to have that information shared with them, and certainly we expect our managers to keep their mouths shut and to act like professionals. That can be a challenge sometimes, you know. If it weren't so, there would be a lot of companies that are bankrupt that are still around, would still be around, because, you know, sometimes we have managers who just can't do the right thing. But the truth is, you know, once something's out, and, you know, I would want our managers and supervisors to be well trained, but, you know, if it gets in the general employee population, it's going to be hard to stop, and I don't know if there's much an applicant that can do. I think we're probably talking about a personal situation there, and if you've got more information, Yolanda, that would be helpful. Feel free to give me a call or shoot me an email, and if I can help you at all understand a certain situation, I'd be glad to. Well, that is all the questions, so we will be sending out those the survey here later on this afternoon with HRCI information and links to the PowerPoint. We also recorded all of this, and so assuming I did it all right, the recording ought to be on the website here today or tomorrow probably. If in the meantime I can be of any service with any of your employee selection issues, I'd love to talk to you about them. But, you know, what pays the bills and keeps my kids in braces and all of that is background checks. And we're a company that, I'm an HR guy. I got into this business after having already been an HR guy, and our goal is to never have to tell our clients we're sorry. So we offer amazing support. Our reports are meaningful, they're accurate, and we stand by them. And you get great service when you call our organization. No call centers in China, no no customer service people who don't understand what we do for a living or can't explain to you. You call here and you're going to talk to our actual analysts who are very helpful and can open the report, tell you exactly whatever the answer to whatever your question is. And hopefully you won't have to do that very often if you're one of our clients, because our reports are easy to understand. But if I can be of any service, please don't hesitate to give me a call. It would be an honor to work with you. I hope everybody has a great holiday. Whatever your holiday you observe, I hope it's meaningful to you and your families. And I will wish you the very best in 2015. Thanks, everybody. Bye-bye.